Hello, everyone. My name is Giulia Gentile, and I am a lecturer in law at Essex Law School. And I will be acting today as chair for this panel, where we will discuss the global challenges in AI regulation. And in fact, our speakers will be discussing and illustrating different complementary and sometimes conflicting, I would say, aspects of the AI regulation world. And we will get therefore insights from a variety of countries, but also legal problems and perspectives. So before starting, some housekeeping rules. We have 5 papers, so it is quite a busy panel. And each speaker will have 10 minutes to present. So I invite all speakers to be mindful of the time constraints that we have. And I already apologize in advance for interrupting them when we're getting close to the 8 minutes mark, to remind them that 2 minutes are left for their presentations. And again, please accept my apologies in advance. I'm just trying to do this strict chairing to allow everyone a fair chance to present and have hopefully a discussion with the audience. After the presentations, we will be joined by a discussant, Dr. Brendan Keenan, who is a lecturer in law at UCL, who will provide comments on the papers. So we will proceed as follows: presentations by the individual speakers, whom I will introduce before their allocated slot, and then comments from our discussant, and hopefully we will have time for a discussion with the audience. So without further ado, please allow me to introduce the first speaker, Dr. Jaspal Kaur Sandhu Singh, who is a senior lecturer in law from Canterbury Christ Church University. Dr. Singh is presenting a paper entitled Enhancing Electoral Integrity and Democracy, Implementing Legal Measures for Content Provenance and Labeling of AI-Generated Content. Please, Dr. Singh, the floor is yours. Oh, perfect. You also set up the screen and you have 10 minutes, please.
Thank you, Julia. That's a very kind introduction. So can everyone see my slides? Is everything all right? Okay, perfect. Very good morning to the organizers, to the speakers, and to the participants who woke up bright and early this morning to hear us speak. So I'm speaking to you from the southeast of England, and although I've got the background of Canterbury Christ Church University, but actually I'm presenting from my little seaside town just outside Canterbury called Whitstable, and it's quite a stark difference from being in the conference in London. But I have to say the sacrifice of traveling to London and back was well worth it. The conference, I must say I have to record my thanks to Nora and her team for the warm embrace on a cold winter day yesterday, and also for hosting us today, albeit online. I'm very respectful for the importance of timekeeping, so I better crack on. So in terms of what I'm presenting today, I'm just looking at whether I've got the slides there. Okay. Right. Okay. So this is just a quick, overall outline of what I want to speak about. But again, considering the time constraints, I'll touch on everything quite briefly. So it's just an outline. It's a work in progress. I have to say, I have to confess that it's a hobby horse of mine. This has become in the last 1 year. I'm hoping to collaborate with the Research Institute in Malaysia, where I'm originally from, And I want to see it take shape as a working paper and to have it presented to the Election Commission of Malaysia for consideration. So I wanted to start by talking to you a little bit about my motivation of this research. And it really started sometime last year when I saw this image or this video of Imran Khan, who is, a member of a political party in Pakistan. And they had used this last year on the 13th, or maybe slightly earlier than December, 13th of December, about how he was basically campaigning using a voice clone whilst he was behind bars. It was part of his political party, PTI party, replication of his voice to make a 4-minute message to headline basically a virtual rally which was hosted on social media. And this was added further when PTI won the elections with Khan still in prison in February 2024. These videos were also clearly labeled as AI generated. So you could see that there is a kind of discussion already beginning between good actors and bad actors, particularly in terms of using AI generated content for the purposes of wooing voters and the electorate. So this is basically the start, really, of my motivation. And if I can find this button, yeah. So why is this so important? Well, 2024 was seen as the year of super elections. There were many incidences of AI-generated content that was viewed as strengthening or perhaps even weakening the electoral process. But what really stood out for me was the gap in the current system, particularly in emerging legal economies, middle income and low income countries, or should I say less than liberal democracies, where there are no comprehensive guidance policies or electoral laws to address what is seen as the erosion of public trust in the electoral process. And what then happened in the course of my investigation is, particularly in the last year or so, is that there is a need to address a kind of deficit in terms of empowering election commissions in terms of regulating AI-generated content, which is produced by political actors and political parties, but also in terms of how this information is being distributed on platforms. Including considering obligations that these platforms can be imposed with vis-a-vis AI-generated content that is seen to be targeting voters. I'm not going to speak too much about the theoretical underpinning because this is something that I think will take a lot of time, but I am considering quite a number of theories in terms of underpinning my research, whether it's the cultivation theory or whether it's the traditional Lockean politics of trust, but also in terms of the importance of trying to extrapolate the economic theory of trust. So I'm very keen on completing reading my current read, which is by Benjamin Ho, around the concept of economic trust and how I'm trying to extrapolate that to this discourse. So in terms of threats of AI-generated content on elections, we can sort of look at it as categorizing it as either mis or disinformation, depending on the harm, micro-targeting, astroturfing, and of course, the technology that we've become very familiar with, which is deepfakes. In the course of my research, I've looked at a number of national jurisdictions. I do have, consideration in terms of looking at, in the context of Malaysia, how the laws on the distribution of election commission by institutionalized national media or mainstream or recognized media, are there any laws in place or duties and obligations in place that are legal, or it could be maybe a code of ethics in terms of the responsibility and obligation in vetting information. I'm also considering and currently reviewing election laws that regulate political parties and political actors, whether the Election Commission is imbued with the power to deal with this new phenomenon that is emerging, which is AI-generated content. And sometimes we, as researchers, we are given some what we call timely gifts. And this was presented to me in the case of a lex specialis, which was promulgated in the state of California. The legislation on deepfakes, for example, goes back to 2019, but it was strengthened a few months ago, just prior to the US elections, to address AI-generated political deepfakes, where there is clear obligations on online platforms to label deepfakes, to criminalize the posting and reposting of deepfakes. And what is interesting is the obligation to actually label content as inauthentic, fake, or false within a particular time period. So in this case, it's 120 days before or and after an election in the state. So for those of you who are interested in exploring this new type of legislation, I've cited those provisions, or should I say enactments, here on the screen. Just thinking, where am I? Yeah, here we go. However, these frameworks have already faced challenges. Back in October, there's already been a block on this law in California because it contravenes the First Amendment. And a week ago, X has decided to institute a legal action in terms of blocking this legislation as well, saying that essentially what it will do is affect the First Amendment of free speech and basically remove or censor quite a lot of political communication or political speech. So in terms of solutions that I'm looking at, flowing from that particular law, I'm considering looking at labeling AI-generated content. And so election commissions can impose this obligation if they so wish to within a national framework, and also to see how the practice of content provenance can help. So very quickly, labeling AI-generated content, we've already, yes, I've got 2 minutes. Yeah.
Sorry to interrupt.
No worries, I've got my timer going, so great. Thank you for that, Julia. So in terms of labeling AI-generated content, we've already seen the EU AI Act as a basis, I suppose, as some kind of a foundational initiative in terms of a legal framework that obligates labeling. So I've cited Article 50 and the recitals 132 through to 137. And of course, the Californian law that I cited just now also speaks about labeling, this obligation of labeling on the platforms. But what is emerging in the field today is this content provenance, which can be basically identifying through metadata information to the end user about a particular content, to see where it originated from, to see if there have been alterations to this content. So it's still at the early stage as to how content provenance can actually help us to sort of reinstill, trust in election integrity. If we feel that, public institutions, or the trust in public institutions, particularly the role of the Election Commission, is to make sure that there are fair and free elections. So it's interesting to explore how content provenance will find its way through. So it's quite interesting that there is a coalition around content provenance that has come about, C2PA. There's been a lot of conversation around this. And that responsibility, however, is in the hands of the industry as to how this particular initiative will find its place. And just in terms of ending this presentation, it was quite interesting. I came across a paper by Moreno, a brilliant paper, if you can read it, published recently, about how perhaps C2PA has been referenced indirectly in Recital 133. I need to explore what I think about this, whether do they really reference it indirectly? This is something for me to think about a little bit more. So just in terms of what's ongoing, I'm mindful of the time. I'm looking at national laws. I'm looking at things like extrapolating models elsewhere into Malaysia, for example, relying on studies of what really is the impact of AI-generated content on elections, and most importantly, understanding the technology of content provenance. And this is where I'm working with a researcher, a computer scientist, and we're going to meander through this together. Final thoughts. I think these are things that keep me up at night, really, honestly. It's the difficulties of trusting the industry again, technology companies and businesses to determine what is truth and fact, And again, I worry that there'll be arbiters of truth and fact, and of course, the constitutional challenges that such empowerment of the Election Commission may result in terms of how it's going to infringe free speech and expression. So that's my time with you this morning. And if you're interested, please do reach out to me. That's my email address. Thank you very much.
This was fascinating, and I'm sure we will have a very exciting discussion at the end with our discussant and the audience. Thank you so much. Next paper then, presented by Kimon Kieslich. I hope I pronounced your name correctly. Kimon is based at the Institute for Information Law at University of Amsterdam, where he works as a postdoctoral researcher in the project Anticipating AI Impact in a Diverse Society. Today, he's presenting a paper entitled Transforming Risk Assessment Practices, a call for a shift towards qualitative and anticipatory methods. This is a co-author paper with Natalie Hellberger and Niklas Diakopoulos. Please, the floor is your, Kimon. And as for before, you have 10 minutes.
Thanks for the introduction. I hope you can see my screen. Yeah. Maybe adding to this, I'm a social scientist, so I'm not a legal scholar. But I think Natalie is a professor in information law, obviously, and Nick is a professor in communication science, journalism, and also with the background in computer science. So we have a really diverse and interdisciplinary team here. And I'm going to present today research from our project, which is entitled Anticipating AI Impact in a Diverse Society, where we developed a method to anticipate risks and impact that are slightly or a little bit more diverging from normal risk and impact assessments. So we started our research from the observation, also from the legal framework, but also from the practitioner's framework, that we see that we have an endorsement of risk-based approaches. And this is like a reaction to the challenges and the opportunities from AI. So we know everyone knows, okay, we have like so much potential, but we also have so many risks that comes with the technology. And so the aim is of the EU, but also of other actors, is always to balance the need to protect the important societal values like health, safety, or the realization of fundamental rights, but then do it simultaneously in a way that is transparent, proportionate, and leaves ample room for innovation. So we want to have the best of both worlds. And again, then in the end, the success of these risk-based approaches and also the legal framework and the regulatory approaches is then critically dependent on methods that we have to actually measure these risks and also define like a threshold of what is okay for risk and what is not okay risk. And then that leaves us to look at what is actually out there. So we looked at the DSA, we looked at the AI Act, and that's mostly Natalie's terrain because obviously she's the lawyer in our team. And my term was more like looking at the practitioner's guides, like really what does NIST say, what does the ISO say, but also what does Microsoft say, what does like the other big tech companies say. So there are a lot of impact assessment as a way of identifying positive and negative impacts early on to safeguard the benefits and avoid its downsides. And we came to a critique of these current frameworks, and we clustered it in basically three divisions. The first is we have a structural critique where we can see that we have serious power imbalances in terms of who decides which risks are deemed acceptable, which are not, and also which are identified in the first place. Then also from the structural side, we have a critical lack of inclusion of non-experts. So it's more like, okay, we have a team of developers, we have a team of experts in companies who are doing impact assessments, but it never actually requires that normal citizens or affected groups, vulnerable groups, for example, also are included in risk assessment practices. And then on the other side, we have a prospection critique. So most of the guidelines and impact assessment that are out there are more guided towards checklists, or like defined criteria, but there is seldomly actually methods to anticipate risks that might emerge in the future, but which are yet unknown. And when we think, for example, of ChatGPT, when it was introduced, there were so many impacts that we actually didn't anticipate and didn't know that they will be happening. And ideally, you would have a method to also anticipate those. And from the methodological side, we found that there's like a strong focus on quantifiable risk. So we also basically always want to have like a metric. We want to have a metric where we can say like this percentage of people is getting discriminated against, or like this percentage is of the systems accurate, and so on. But there are also things that are inherently difficult to measure. For example, human rights. And of course, again, you can measure it on a scale, but then this is also dependent on an expert judgment in the end. So it also fails to actually reflect the lived experience. So based on this critique, what did we do? Then the social scientist in me, and also Nick and also Natalie comes in and is like, okay, we need to develop a method. That's what we did. We called it scenario-based social technical envisioning. We did 3 empirical studies yet on it. We have more studies ongoing. And I'll present to you like the concept of it. So 3 terms: scenario-based. That means we lay focus on narratives. So we that comes later in, we let people write stories. Narrative make complex issues visible and more accessible for a broader audience. We have the socio-technical aspect. That means that we actually want people to describe a situation, like how they engage with technology, because like all this contextual information is relevant for a risk or an impact to actually emerge, and also to understand how people interact with this technology. That is also something that's not really captured in the current assessment. And the envisioning aspect means we look forward. We look, for example, 5 years in the future and say like, what might plausibly be happening in the future if we proceed the way we are doing now with technology development. In practice, that means we are doing surveys or workshops, depending on the goal and depending on who we want to reach out to. So we did workshops at some conferences, for example, legal practitioners. We did workshops at journalistic conferences to journalists, when it is for the impact on AI on the news environment, for example. But also we did surveys. So we just have like a survey provider and then ask like normal citizens to provide us with their anticipations. And the core of this method is a writing task. So it's like really a 30-minute or more exercise where we ask people, please invent a fictionless character who is then confronted with a specific technology which we describe to the participants, and also really lay out how this character then interacts with a specific technology, for example, Gen AI in the news environment, which leads then to impacts. So we task them to write something about technology interaction, and then some form of impact that can be positive, can also be negative, depending on the goal. And then at the third step, we normally have like a complementary reflection task where we ask, for example, so you described now an impact, what would you do to mitigate the impact out there? And then we can also derive like more strategies that also leaves us more way to and room to actually explore alternative approaches on mitigating harm. We emerge then with stories like these. These are only short excerpts. That is a study that we published in AI and Ethics earlier this year. For example, in the first one, you see there's this character Hans in the Netherlands, who is a journalist, a photojournalist, and he then uses AI to generate photos, and he basically creates misinformation, brings other people in troubles, and then in the end, he's getting fired and faces a lawsuit. That is, for example, one story that we found. Under there is here another story of a person called Robert, and who also is a journalist, but then faces all these structural changes, and also in the end is basically helpless of the AI. We also have positive scenarios. These are just one that are really this topic. And what we're doing afterwards is we collect all these scenarios. In this study, we had over 100. And we can do different things with that. So for the one hand, we can have that as narratives, as standalone future projections. For example, if we just say like, this is one version of the future.
Sorry, yes,
yeah.
2 minutes.
Okay. We can do bottom-up impact assessments, and we can also quantify some form of the impact here if we reduce complexity, and we can also develop new mitigation strategies. So exemplary results from our first study. That is only an excerpt again of what we found out. So we came up with, I think, 50 specific impacts out of 100 stories. And then we can always connect it to our example quotes. For example, here, the public trust in the media has been utterly shattered for a good reason too. And then we can describe with the story how this came to the loss of trust. And we can develop, as I said, like mitigation strategies. These are also answers here from our study, where we could also see here, for example, that the only comfort that she could find was the law that was created after her case, that none project could be downloaded or screenshotted without the customer service approval who were responsible for checking the content. So actually here, a legal proposal of how it could be done better. And that brings me also to the end of the presentation. So we have two goals with this project that we want to do. So we want to provoke a shift in current approaches to risk and impact assessment. We don't say that it's all is useless out there. We just say it's very, very one-sided, looking at metrics and looking only tasking experts to do that. And we also provide these toolbox for scientists, policymakers, and legislators to use it in their future work. And we're currently drafting the conceptual paper of that, and we also want to soon publish a guidebook on how actually to apply our method. And I think that's my 10 minutes. Thanks.
Thank you very much, Kimon. This was exemplary. You even finished before your allocated 10 minutes. So very well done. I mean, this is really intriguing. I'm really looking forward to discussing this methodology and learning more about this. Thank you for your presentation. The floor is yours, and as for all the speakers, I will let you know when you have 2 minutes left to present. Please.
Thanks so much, Julia. And hello, everyone. My name is Wen Long, and our paper actually starts with a very simple question. Is it ever lawful to train a generative model using personal data without consent? Quite a mouthful. But it turns out that this issue is far from simple. And our approach, I think, is not quite typical, as we're not actually thinking about how we reach out a conclusion on this, but whether consensus would emerge at the global level from authorities worldwide and what they would consider as the best way forward, and the potential implications for companies worldwide. And also to say that this is a collaborative project. I have colleagues Yueming Zhang and Qingqing Zhang from Ghent University and Shandong University as well. So let's start with a story about LinkedIn. So probably many of you, if you're are on LinkedIn or Twitter, you'll probably be engaged in this kind of controversy about LinkedIn's turned-on toggle on using personal data for training their models. And this is even before their terms of service was updated, as reported by 404 Media. And after that, they have a dedicated page on their help center as to what is their generative AI and what are the remedies and tools for users to control how their personal data are used. So lots of discussions online as to whether people have reasonable expectations on how their personal data are used in this context of AI, and whether consent is required according to the GDPR. and more broadly, what's the best way to regulate this kind of practice. So it's not our paper actually to engage this very substantive matter, but we do have an overview of literature. So, for instance, Pablo from VUB wrote a paper last year indicating some practical challenges of consent as a legal basis for AI training, and with emphasis on safeguards and adherence to purpose limitation. This year, we have another paper from Tanner Crew from Tilburg on IDPL. And his arguments mainly that the necessity and proportionality tests are unlikely to be achieved according to the Meta case, due to the potential violation of data minimization principle. And there's another issue on top of that about sensitive data processing and the potential applicability of the manifestly public exception to this case. And his argument is that although this exception may apply, what's in that training data sets is not limited to those script over the internet. And also another paper from a rather new journal of law and AI regulation by Tini, Dora, and colleagues, arguing that there's no choice but a legitimate interest given the impracticability of consent, but they also come up with the practical challenges about legitimate interest as the basis for data for AI training, by indicating the unfeasibility of pseudonymization, opting out, and emphasizing on thorough documentation. We've noticed some opt on social media as well. A quite good one is from Peter Craddock, a lawyer in the field of data privacy, and his long piece is primarily about whether personal data exists in the context of AI training, given that lots of data are actually tokenized. And that questions the applicability of the GDPR in the first place. And then an interesting contribution from Peter, I think, is that when selecting a proper data lawful basis, consent does not prevail over legitimate interest, or is not appropriate. We also have a piece from Sophie and Pablo suggesting a blended approach to this matter. Our approach actually looks at guidelines that has ever issued by authorities worldwide, and also the regulatory actions against those companies such as Meta. So this is the fun part. Thanks for Yueming's continuous and effort. We've managed to put all the guidelines ever issued from last year on the same page that indicate how disparate and inconsistent that authorities are on the matter of legitimate interest and consent when it comes to AI training. Probably I don't have time to go through all of the details, but as you can see that quite a handful of authorities actually would support legitimate interest as a permissible basis for AI training. But the devil's only in the details in terms of, for instance, whether individuals have reasonable expectations as part of the legitimate interest analysis, whether AI training is by itself at high risk processing, etc., etc. In our paper, we also look at enforcement cases, and we do have a tracker as well that showcases the ongoing investigations when it comes to AI training. Again, I'm mindful of the time left, so probably not be able to go through these chart, but I do have a condensed view of 3 cases that we now have some level of certainty The first one is the guarantee vis-a-vis OpenAI. Last year, the ChatGPT was temporarily suspended, and then the suspension was lifted when certain compliance requirements are met. And this year in Brazil, Meta's AI was suspended by the AMPD as well, and a couple of requirements were suggested by the AMPD and met by Meta. So that suspension was lifted in August, the end of August this year. And also in the UK, the ICO engaged Meta, leading to the temporary suspension as well. And then the ICO very explicitly and proactively endorsed Meta's compliance plan that rests primarily on legitimate interest. This is
2 minutes.
Yes, thank you.
Sorry.
I think that will be enough. This is how it is a simplest view of how these authorities think about the measures and remedies that are necessary to ensure that these AI training practices are compliant with law. As you can see, actually, there is some consensus on, for instance, opt-out transparency and also the protection of children. But looking on the right side, you will find some more complex issues such as data dark patterns, sensitive data processing, and private data processing that are less engaged, and also hallucination as well. So lastly, some reflections. We find that consent might appear impractical, but still there is some scope for this role. In the case of first-party data, that is how we provide prompts, files, and other data voluntarily to AI products. And this has been discussed by the EDPB in their October stakeholder event. Legitimate interest plus opt-out stands out and ad hoc. I will not use solution in this instance as Dana proposed yesterday, but still imbued with uncertainty, as quite a number of tests are actually need to be addressed and incorporated. And currently, the authorities are actually picking low-hanging fruits with some difficult issues unaddressed, as previously mentioned. And lastly, you will find that those tools and remedies are only provided to certain jurisdictions, where some users actually provided with the ability to opt out and others not. That brings me to the end of my presentation. We managed to write the paper up before the conference, but we managed to submit an opinion to the EDPB concerning its guidelines on legitimate interest. So if you're interested, feel free to click the link and reach out to us via email or LinkedIn. We're all on LinkedIn. Thank you.
So this brings us to the end of the presentations for this panel, which means that now it's for our discussant, Bernard Keenan, to take the floor. Bernard, oh, perfect. I can see you. You are connected. So the floor is yours.
Thank you, Julia. And thank you to all the speakers. Really great research. Very interesting questions. As always, it's a bit of a challenge to draw together a panel, but I suppose there's a couple of things that I would sort of premise my comments with. Let me just move this document down so I don't appear to be looking over everyone's head. Okay. So I think what's interesting to me about any situation where a new communication media are being rapidly deployed and altering society is that different social systems are faced with a kind of surplus of possible responses. And I think in all of these papers, if there's a uniform theme, it's this uncertainty and this multiplicity of different options. And the really difficult work that everyone is doing is in trying to sort of imagine or to think through from our existing resources in the legal system what to do about which options to choose, or at least to describe which options seem to be emerging. And of course, the underlying problem is whether or not the legal system retains its kind of role that it previously occupied in relation to these risks and processes and ways of organizing communication. So with that kind of general point made, maybe I'll just ask a few questions of each speaker and maybe try to play a little bit devil's advocate with Sam. So with Jaspal Kaur's paper, yes, I mean, this is really interesting, and it's when we're talking about any kind of question about legalizing a political process, we're sort of faced with the paradox that modern law relies on political validity for its own validity. So, the law is made by elected legislatures, but then law somehow has to regulate the way in which a legislature is constituted. And this fundamental problem cannot really be unpicked, but it means that, of course, any legal measure to control how we go about constituting a political body is always going to be politicized. And so I suppose that leads to the whole history of, whether or not, we should restrict speech in any way. And we see very different responses depending on the jurisdiction. And I think the examples from the United States are just so interesting when we compare it to maybe what we might expect under the kind of European human rights regime, certainly from my research interests, but more broadly around the world. I suppose my own instinct is to think about the way in which, and maybe this is a sort of challenge, or I don't think, I know I heard you just, Paco, that you're wrestling with these problems, so you're not asserting a sort of solution. But, I think it's interesting to reflect on the way in which these similar problems existed in the past, and the way in which, under the conditions of the mass media, the broadcast mass media and the print mass media, people similarly had crises of faith and crises of truth and weren't sure what to believe. And yet, we do get by pretty well, choosing which media we want to consume, whilst understanding that they are filtered and that they are biased and that they are paid for in different ways. And so I wonder if there is, my instinct is that probably on the side of not wanting to regulate too strongly, because if I take the example of like the UK government wanting to question Elon Musk and Elon Musk kind of promoting things that were associated with riots in the UK in August. I mean, I think that at the level of the social, we could say that this is also a major learning opportunity for people in terms of how they assess Elon Musk, rather than simply a kind of threat from the technology. So that's not expressed very well, but that's my own response to that. So does second order observation just kind of take care of these problems over time? For Kimon, I think this is a really interesting set of problems. And of course, it opens up a whole series of other paradoxes. But I think what really leaps out to me is, from the research, is how much risk is socially constructed, that it sort of arises from modern society's expectation that decisions are what sort of most influence the future. And in that sense, it's not a very new kind of problem. Like, we've had more or less a risk society since the 17th century at that level. But this quest for looking for solutions at a kind of meta level opens up some really interesting perspectives. And I think the research is great. I'm always interested in the way in which we can sort of differentiate between risks that are attributable and that are somehow like registered and entered into some sort of calculus, versus kind of danger, which is something that always operates in the environment and kind of comes in unexpectedly. And so this this way of kind of unpicking this interdisciplinary research where you unpick social construction of risk, both at the high level of what the legal system says a risk has to be constructed as, versus how that might be carried out organizationally and in different technological platforms, versus how it actually might be imagined by those who are potentially affected, those for whom these risks are actually experienced as dangers. That's interesting, but of course it does always mean that the distinction re-enters, right? So that someone is affected, someone is always endangered. And sort of not everybody can be kind of included in the calculus of risk. Which isn't to say we shouldn't expand the attempt or consider what happens when we do. So I'm really fascinated to read this work. For Olena, I think what I'm really interested in, Olena, and this is obviously again a re-entry of the political, but for the past sort of 25 years, we've had a lot of concern amongst social scientists about how in spaces of war and spaces of emergency, the ordinary operation of the norm, the law is suspended. And in that space, the war theater becomes a kind of laboratory for new technologies and for new ways of sort of obviously for doing violence and for control. And I was wondering if you have a view on this, to what extent in Ukraine at the moment, do you feel that that there is a sort of rush from AI companies to try to deploy and to experiment with technologies that may not be palatable in other circumstances? So to what extent does the emergency justify doing things that exceed what seems to be discussed in these AI frameworks elsewhere? And then finally for Wenlong, I hope I'm not going on too long. Again, like
you're fine.
Okay, great. What a great example of surplus possibilities, which is, what I sort of said at the beginning, that the even in such a well-defined, highly technical framework like data protection, which is the kind of, we thought was the sort of cutting edge of digital regulation. Suddenly you have this deployment of generative AI, these modes of kind of artificial communication. And suddenly, what seemed to be a quite well-defined, I mean, there's always been ambiguity, of course, between these different justifications for data processing. But it's fascinating to see how open this is. And the point that you make, of course, then that really what kind of rights you have at the moment are highly contingent, not on which platform you're using, but where you're using it. And so yeah, I mean, I don't have much more to say than that. I have no insights into the future, unfortunately. But fascinating work, and well done, everyone. It's really so valuable to be able to hear all this, and I look forward to reading. So yeah, I'll stop there.
So let me introduce myself. My name is Richard Danbury. I'm a senior lecturer in journalism at City University of London, and I'm also attached to the Information Law and Policy Centre as an associate research associate. Enough for me. So this session this morning or this afternoon or this evening, depending on where in the world you are, it's panel 5. It's on public safety and AI. And we have a variety of different speakers, Dr. Nessa Lynch from University College Cork, Rita de Souza Costa from the University of Algarve, Amir Kahan, and please forgive me if I've mispronounced your name there, from the Hebrew University of Jerusalem, Professor Marion Oswald from a number of places, including Northumbria Law School and the Alan Turing Institute. And we're also very lucky to have Dr. Lawrence McNamara, who may or may not be with us at the moment because he was having difficulty getting in from the Ministry of Justice. Oh, I can just see him. He is there, who is from the Law Commission.
So thank you very much, Dr. Richard, and thank you to the Center, to Dr. Nora for organizing this fantastic event. Hello, everyone. My name is Rita. I work also as a practitioner in the field of ICT law, particularly focusing on data protection and privacy. So this is likely the reason why I tend to approach this topic through GDPR lenses. So this presentation is divided into 4 sections. First, we'll discuss briefly the Whistleblower Protection Directive vis-à-vis the GDPR. Second, we'll analyze challenges posed by conflicting rights under these frameworks. Third, we'll explore how AI can help to address these challenges and the risks it poses. And finally, we'll conclude with a few strategies for mitigating those risks. So let's get started. Okay. The Whistleblower Protection Directive was adopted in 2019. It came as a response to those high-profile scandals that emerged at the time where whistleblowers brought major breaches to public light. So the EU legislature saw the need for a legal framework to protect people from retaliation, people who report breaches. But interestingly, the directive doesn't define the term whistleblower, even though it mentions it in the recitals. Instead, the directive defines what is a reporting person. And this definition really shapes who falls under the directive. So the reporting person is defined as a natural person who reports breaches whose information was acquired through work-related activities. So this is really key, work-related activities. So anything outside of that, it's not covered by the directive. So, for example, someone who acquired information in the context, let's say, of a cyber attack, for instance, this is not a reporting person under the directive. And as a result, it's not subject to the protection of this directive. So this is very important to bear in mind. The directive also protects other people who are close to the whistleblower, the reporting person, like witnesses, colleagues, relatives, or facilitators, then those are defined, are those who help the reporting person. And these people could also face retaliation, so they are granted protection, of course. And then we have the person concerned, which is the subject of the report. Usually we associate this person with wrongdoing, which is quite accurate normally, but it's important to remember that everyone is presumed innocent until proven otherwise. And this is a key principle in any system ruled by the rule of law. So this is something also to bear in mind in the context of internal channels. Well, under the GDPR, all these individuals are data subjects, which means they have rights also, like rights to access, rights to rectification, to be forgotten, etc., among many others. Additionally, organization managing reporting channels, they are the controllers. This is really clear. And for example, if there are some outsourcing in the platform, these will be considered possessors. So, in this presentation, I will not develop the relationship between the GDPR principles and the Whistleblower Protection Directive, but I did this before back in 2020. If you are interested, this is the reference. So let's talk about one of the big challenges here, which is, in my view, balancing confidentiality with GDPR rights of all these individuals. So confidentiality is at the core of the directive because it is really instrumental to the protection of reporting persons from retaliation. This is quite obvious. And this is something that applies to all the implementation of the channels. So especially if some tasks are outsourced, for instance, it's important to have in mind things such as the data processing agreement under Article 28 of the GDPR, security measures under Article 32. However, if confidentiality is at the core, the question that arises is how this reconciles with the exercise of rights. So think of the case of the reporting person, of the person concerned, and especially the person concerned's right to access under Article 15 of the GDPR. How do we reconcile this? Well, one option could be to deny access entirely, but I don't think that's the right approach. Instead, I think these rights should be obviously restricted, but not denied outright. So this needs to be done, of course, carefully to ensure that confidentiality of the reporting person is not compromised. So can AI solve these problems is the question. AI can play a big role here. For example, AI can help pseudonymize or anonymize data in reports. This isn't just about removing names or numbers. It can go deeper, like redacting writing styles or other identifiable information. So there's some interesting research on this, like the work by Professor Bettina Berendt and her team, which tested AI systems for anonymization in this context. The reference is there. But AI can also automate simpler tasks. For instance, the directive requires an acknowledgement of receipt to be sent to reporting persons within 7 days. This can be automated with basic AI setup. Other use of AI can also be the help it can provide in processing large amounts of information, such as reports analyzed in the context of investigative journalism, for example. And now we enter in these 3 final examples where AI can detect patterns of wrongdoing, predict patterns of possible retaliation, or automatically report. So these are the cases of the so-called whistlebots for the purpose of this presentation. I read this expression in the literature, in the reference is there. But in this case, what is interesting is, in this case, the whistleblower or the reporting person is no longer a natural person, but an AI system itself. So this is really game-changing, because we no longer are preoccupied with protecting the whistleblower, which is the aim of the legal framework, the directive. But now we are preoccupied with protecting others against what these AI systems can really do. So what are the risks? Well, these are the ones that the directive addresses. Obviously, reporting persons can be vulnerable to retaliation, so this is relatively clear. But what the directive doesn't address is the risks directly posed by AI. So one major risk is the well-known algorithm bias. This is a common problem of any AI system, and something that the AI Act tried to address. In this case, this is particularly important. Think of, for example, whistlebots that are intended to predict patterns of wrongdoing. If they are badly trained or with data sets that are not accurate or that have some bias, then, well, the results might be terrible. And they can, in this regard, increase also the number of false positives. And false positives can really be dangerous, actually, because most of the time they are a consequence of lack of human oversight, or even a consequence of algorithmic bias as well. And finally, obviously, this poses challenges to transparency as well. This is probably the one you are more familiar with. There are a huge amount of research on algorithmic explainability under Article 22 of the GDPR, for instance. So, some risk mitigation. I like to divide this in 3 sections, and I like Latin. An a priori assessment, I would say an accountability stricto sensu, maintaining the Latin, and an a posteriori assessment. First, with regard to these a priori assessments. This includes things such as data protection impact assessment, DPIAs. I argue, as the UK Data Protection Authority, the ICO, that whistleblowing procedures are subject to mandatory data protection impact assessments. This is not so clear in all jurisdictions across Europe, subject to the GDPR, but I think it's clear that the processing activities can result in high risk for freedoms and the rights of data subjects. But the different scenario, however, is the fundamental rights impact assessment at least in a way as it is set out in Article 27 of the AI Act. And this is because, as you know, and there are lots of discussions on this article, the scope of application is a bit disappointing. It's a bit narrow, at least compared to the GDPR, DPIAs. But in any case, even in cases where this is not mandatory, which might be the majority of them, conducting this assessment might be useful for mapping the risks of the deployment of certain AI systems. However, this doesn't apply in all reporting channels because many companies or authorities might not use AI risks, high-risk AI systems, or might not even use AI systems at all. So, and to conclude, with regard to the accountability, it's obvious the organization needs strong policies and clear roles to avoid one of the major risks and one of the major challenges, which is prevention of conflicts of interest. This can be tricky. Imagine this example. What if the person you are reporting is, for instance, a board member? One solution could be to assign oversight to compliance officers or non-executive board members.
Sorry to interrupt a little bit here, Rita. We've gone a little bit over here. Perhaps you could bring it to an end. Now. That would be helpful. Thank you very much indeed.
So, and then with the regular audits, I would suggest one per year, and that's all for me. Thank you very much. Sorry for running over time.
No, I'm sorry for interrupting you. I wish we had more time. Perhaps next year we can have a whole thing devoted to this. Thank you very much indeed, Rita. Right, so now we pass over to Amir. Amir.
So, hello everyone. I'm very happy to join you. My name is Amir Kahana. I'm a PhD student from the Hebrew University in Jerusalem, and my main research interest is surveillance law. The paper I present today is mostly descriptive, and it charts an account of police acquisition of surveillance technologies, which has gone all wrong by way of maybe 2 or 2.5 examples. So the paper does so with 2 test cases that involve AI technologies. The first is the introduction of license plate recognition technologies, LPR, and subsequent attempts to sneak into the legal framework that govern them, also authorization for facial recognition technologies, FRT. Well, this is the half of the 2.5 cases I mentioned earlier. And the second is the use of an AI profiling system at border checkpoints to flag potential drug couriers. So in the past decades, maybe a little more than that, Israel police has been acquiring more and more surveillance technologies. The most notorious example of those is the NSO's Saifan phone hacking tool, which was supposed to be a downgraded, legally compliant version of what you may be familiar with as the Pegasus tool. But the Israeli police has been also looking into acquiring other capabilities such as ADINT, geofencing, as well as LPR, FRT, and AI profiling that I will discuss today. This surveillance arms race of the Israeli police might be attributed to, let's say, a general conception of technology as a panacea for HR, budgetary, or operational challenges that police forces face, but it may also be attributed to changes in police manpower, in which a former deputy director of the Shin Bet, which is Israel's internal security agency, equivalent of the MI5, let's say, he was nominated to serve as an inspector general. Subsequently, counterterrorism methods and the counterterrorism mindset were becoming more and more embedded in police investigative and surveillance measures. But regardless of the underlying reasoning, Israeli police has been acquiring various surveillance technologies while having questionable legal basis to use them. There's a pattern emerging similar to what happened in the NSO case that I couldn't elaborate on due to time constraints. First, acquisition of said technology, then clandestine use, followed by some sort of a journalistic revelation and scandal, which brings forth some sort of suspension of operations or an effort to rectify the applicable legal basis. Again, due to time constraints, I can only mention in brief that, subject to an exemption clause in the privacy protection law in Israel, the legal analysis of police use of surveillance technologies remain only within constitutional boundaries in a proportionality analysis. In this context, a crucial element of the analysis is the requirement that any proportional infringement on applicable rights, including privacy, must be made pursuant to explicit statutory authorization. So during 2019 to 2020, the Israeli public became gradually aware that the police has been using an LPR system called the Hawkeye. Hawkeye is employed for two operational purposes. First one is the real-time detection of flagged vehicles and thereby the flagged individual who may or may not be driving them. And the second purpose is post-hoc investigations that are based on the accumulated data obtained and processed by the system. Following several exposés in media, an NGO, the Association for Civil Rights in Israel, ACRI, petitioned against police use of the Hawkeye system without the police having any explicit statutory powers to do so. In response, the state claimed that the authority of the police to deploy and use the system is in accordance with its general statutory tasks to prevent and discover criminal activities, or its general statutory duty to investigate crimes. But despite this line of argument, the High Court of Justice issued an interim order ordering the police to provide reasons why should it continue operating the Hawkeye system without an explicit of statutory authorization. And what followed was a prolonged legislative process to authorize police use of LPR. Since we're short in time, I cannot describe it in details, the various attempts, the various versions and drafts of the special cameras law, the one that eventually came to regulate police use of LPR system. I will just stress one point that the first draft attempted to basically authorize also police use of facial recognition under the same identical legal framework that pertains to LPR systems. Later draft versions attempted to craft a distinct regime for FRT system, acknowledging the sensitive nature of facial recognition. These attempts were critiqued both on privacy grounds and on, let's say, AI grounds or algorithmic bias ground. Even within the government, there was a minister of Ethiopian descent who was concerned of the racial biases that are typical of FRT system. However, in light of the pressure stemming from the pending case in the High Court of Justice, by September 2023, the bill was reintroduced with any references to facial recognition carved out, and the special cameras law eventually passed in this form, authorizing police use of LPR only. Despite the removal of the FRT chapter from the special cameras law bill, the Israeli police continued to push for FRT authorizations. On various occasions, we see the police opting for an authorization to deploy FRT, either for preventing soccer hooliganism or for crowd control during LGBT pride marches. So far, this serves as an indication that the police has already acquired the technology prior to obtaining any legal or statutory authorization to use it. Another test case revealed in 2022 when it was discovered that the Israeli police have been using automated profiling to detect drug couriers in the Ben Gurion airport, which serves as Israel's main international gateway. The profiling system in this matter flagged arriving Israeli citizens that were later detained by border control for questioning. And the particular news piece was pursuant to a case where a suspect that was flagged by the system as a potential drug courier was searched and found to actually have drugs in his possession. And in his trial, he argued not only that the search was illegal, but also that he was unlawfully profiled based on his sexual orientation by the system. So without delving into the procedural history of that case, it should be mentioned that in a motion to disclose evidence pertaining to the system in question, the district judge ruling on the matter pointed out that the system is, first, it's a machine learning model with unknown weights, and he further quoted two police officers referring to the system as a black box. So although he did not determine that the system was biased. The district court did express concern of insufficient explainability in consideration of the system's age and the fact that its statistical model was not revised or reviewed at any point. This public revelation of the existence of an unchecked criminal profiling system at the border prompted a parliamentary hearing in the Knesset, as well as a constitutional challenge by Acre, similar to the one in the Hawkeye case. However, this petition was recently removed from the docket, recently being last week, following a police submission that the profiling system is no longer in operation as of April 2020 due to so-called operational concerns. Operational considerations. This kind of strikes me and others a bit odd, as this information was not divulged before neither the Knesset, the Parliament, or the court in any other suitable occasions. So as final remarks, these two cases of AI used by the Israeli police are an example of a disturbing pattern of, let's say, acquire first and ask questions later. The police has procured both systems under a veil of secrecy that is afforded to classified investigative measures with no effective internal oversight, raising concerns, nor designing a suitable legal framework or code of conduct that can support their use. Only once the existence of these surveillance technologies was made public by the media, then public debate and subsequent constitutional litigation prompted institutional response. As a takeaway, we can see the importance of the court in matters pertaining to police or national security surveillance technologies. While the court does not act as a norm setter, it repeatedly sets the red lines beyond which the police cannot operate without statutory authorization. And then the legislative branch may, in its turn, set control and safeguards for the use of such technologies or decline to legalize them altogether, as the Knesset insofar refrained from authorizing the police to use authority. A potential policy solution might be introducing legislation that regulates police acquisition of surveillance technologies, let's say, coupled with stronger transparency and oversight. I will happily elaborate on that in the Q&A. Due to the wish not to exceed my time, I'll thank you very much.
Thank you very much indeed. We now for our last speaker, we go to Professor Marion Oswald, who will talk about what role can data ethics oversight play in mitigating the risk of a probabilistic AI chain reaction in law enforcement. And looking beyond that, we are going to go to Lawrence, who will hopefully draw some threads together and pose some questions for our panelists. Marion.
Thanks very much, Richard. Hi, everyone. My name's Marion Oswald. I'm a professor of law at Northumbria University and also the lead of the 4-year Probable Features project, which is a project funded by the Responsible AI UK programme. And we are a interdisciplinary, multi-institutional team. A few of our pictures here, based in a number of different universities and with expertise across law, computer science and social justice in particular. Our project, as you might expect from the title, is all about probabilistic AI, focused on the fact that AI gives you a statistical output, not a fact. And that's a very important thing in the law enforcement context. And we're also really interested in the chaining of systems, hence the photo on the screen there and our little P logo, which was intended to look a bit like a chain. So why are we interested in this chaining of systems issue? It's because we're concerned about what sort of pipeline of uncertainty and cumulative effects the use of probabilistic AI is going to result in across the whole law enforcement context, not just policing, but across the whole of criminal justice. And perhaps I could give you a hypothetical but plausible example of something that might occur. So perhaps the police are monitoring a student protest. A police force deploys an AI weapons detection system. It's linked with live facial recognition, as we've just heard from Amir, and perhaps the passport database. Following a hit, the police force creates an intelligence record about a young man stating he was likely carrying a gun. The individual knows nothing about this record, and the police force themselves do not know that there are three other facial recognition hits that only just failed to reach the system's threshold, as the tool doesn't inform the user about this. The weapons detection system has a high false positive rate, especially for umbrellas in bags and pockets, and it had been raining on that day. A second police force uses the individual's record to feed into a machine learning risk assessment tool, the sort of thing actually that Rita was talking about, and concludes that the individual is likely to commit a future serious crime. And then the housing authority uses that conclusion to serve the individual with an eviction notice from his social housing. So neither the second police force in that example nor the housing authority know the origins of the information they use to make their decisions, nor the underlying uncertainties and tool parameter settings. So it's this pipeline of uncertainty and cumulative effects that we're concerned about. And our ambition is for the deployment of probabilistic AI within law enforcement to achieve a one consistent system approach, and with that justice and responsibility at its heart. And to do that, we've got a number of work packages and objectives that revolve around mapping the ecosystem, thinking about law enforcement of the future, thinking about how AI might be deployed in a trial situation, a criminal trial, and also thinking about oversight, what best oversight methods and bodies might help us in the future. And that's what I'd specifically like to talk about now. We're building on some research that we've done in the past, which was funded by the BRAID project through the Arts and Humanities Research Council. And this was an evaluation of one of these bodies that aims to provide oversight and scrutiny to the use of police data analytics and AI. That's the West Midlands Police Data Ethics Committee. And as Nessa said, there are a number of different bodies that are aiming to do this sort of thing. She and I both sit on the New Zealand Police Emerging Technologies panel. Nora and I both sit on the Home Office's Biometrics and Forensics Ethics Group. So the aims of these types of bodies are very similar. The West Midlands Committee was set up in 2019 to work alongside the force in its data analytics activities. So our role is to give advice and recommendations to AI and data analytics projects as they are developed and piloted and then rolled out within that force, which is one of the biggest in the UK. It was interesting that in 2022, the House of Lords Justice and Home Affairs Committee said that this sort of process conducted by the committee is relevant because it has a specific focus on technological solutions, and recommended that this sort of process be considered as a national form of scrutiny of the police use of technologies. So our research tried to look at what influence the committee had had on policing projects, and specifically how were human rights issues identified and picked up by that process. We also were interested in how marginalised and vulnerable groups were dealt with, were their interests and concerns actually incorporated within the review process. So to just give you a few examples of the findings, we did find that the committee's advice influences the development of projects. Things had been changed as a result of the committee's advice. And it did contribute to transparency and building that knowledge of good practice. But perhaps more importantly, the committee did create knowledge within the police force itself. So police staff and data scientists actually anticipated the concerns of the committee and then were able to build those into their project planning. We also found that there was a strong human rights focus, and again, engagement with the committee had informed police representatives and transformed in some respects their understanding of human rights issues. But we also found that perhaps committee discussion was overly focused on human rights related to privacy and discrimination, and there should have been more focus on issues of fair trial and the state's positive obligations under human rights law. Really importantly, there was a big concern that often information was missing about how AI tools and data analytics were going to be deployed in real world operational contexts. And so it was crucial that information was provided and thought was given to that operational deployment. So in terms of conclusions, and to think about the question that I asked right at the beginning of this presentation, certainly these types of bodies can contribute to the robustness of technology implementation in policing, but they have to be incorporated fully into the process and not be seen as some sort of add-on exercise. They do need to incorporate the voices of the community in order to improve trust. And that is a very difficult thing to do and not something that we have done successfully yet within the West Midlands process. And there are really no black and white answers to a lot of these questions around proportionality. And that's why these types of processes cannot be seen as providing a total solution to this issue of chaining the consequences of using probabilistic AI in policing. Our project is all about responsible AI, and I like to think about that as a question of whether AI should be using it. So to avoid the sort of thing that Amir was talking about, acquiring first and asking questions later, we should be doing the other way around, asking questions first and then only acquiring if that's the best thing to do. And all of these things on the slide, technical, statistical, legal, operational, contextual, and ethical issues are all relevant. We can't just look at one or a few of those. We have to look at all of those issues in order to think about responsible use of AI. And I do think if we do that and if we achieve it, we are going to make progress in this area, but I think we've got a long way to go. Thank you.
Lawrence.
Thanks, Richard. Look, thanks to everybody for that. I will try and limit my comments to 5 minutes. They are going to be framed in some ways as questions, but Richard, I'd be very happy to defer to people coming in on the chat in terms of the questions that might be of interest either way. So I suppose, look, my first thought is that I come at this from a particular point of view. I was for a long time an academic, and I currently work for the Law Commission as a law reformer, as a lawyer there. I do not speak for the Law Commission in these comments that follow. I also worked for quite a while for a rule of law body. In posing the questions I'll ask or the comments I'll make, I think there's a general point that comes out of some of this, I think, which is that the questions we ask are often the questions we're familiar with. And I think it would be really important in this context for any of the presenters in any way they engage with stuff to tell people they're not asking the right questions. Because I feel that over time I have sat down around debates around surveillance and privacy and the rule of law. And one of the things about lawyers is they ask questions they can understand. And those questions tend to be about the law. And I do think one of the really important things of all of these papers is a really rich understanding of the technology. And so I think that is something I think I would say to all presenters. People need to be told if they're not asking the right questions, or if they're not asking questions that are sort of should come a bit further up. The second thing I think I would observe that comes across in all the papers, and this is a question that constantly arises in a law reform context, is how much of what, to solve problems or to make things happen, how much relies on law and how much is actually not about the law? And so I think that comes across in all of the papers. There are things that legal frameworks can do, but there are things also that actually aren't to do with the legal frameworks. And just separating those out, I think the papers did that in various ways really quite well. And for some of the issues, the law and the legal framework is absolutely crucial. But for other things, these seem to be much more questions of practice and developing, with Marion's being the kind of most explicit, is developing ethical sort of responsible processes around there. The next observation I'd make, which I would be really interested in, is how much language matters in the conversations that are had in sort of public safety, law enforcement, intelligence and AI conversations. So the language Nessa used, for instance, of intrusive technologies, Amir spoke about lawfulness. There's questions then, as Marion put, of responsibility. To some extent, how much are you trying to persuade stakeholders that are working in these spaces that what they need to, the terms they need to be talking in and thinking about are, for example, responsibility, or are they about lawfulness? And if they are about lawfulness, is it about that question of what's a floor or what's a ceiling? And I'll come to that in a moment. The next question or comment I sort of have is a reflection on the pace of change. So technological change is obviously being introduced at pace. And Amir's point that Marion also raised, well, technology is acquired prior to having the statutory authority to use it. On the way to work yesterday, I went past a little sign in one of the tube stations in London that reassured me that I'm very safe because there's 150,000 cameras on the rail network that the British Transport Police have access to. I'm not 100% sure how safe that made me feel. But nonetheless, it really strikes me across all of these things, if the level of change is introduced at pace, what needs to be the pace of a response? And I do wonder to some extent, to what extent has that ship already sailed? And it might be it has sailed in some contexts more than others. And so the whistleblowing context, for example, might actually be an area where it is a work like Rita's is a bit ahead of the game. I'm not sure. The fourth point, and I have my stopwatch going, Richard. The fourth point I want to make is one about the limits. So NASA's point about the directive giving the limits up to which a jurisdiction can legislate, being treated as a floor, not a ceiling. And I think, I've seen this a lot in my own research, which could have focused a lot on exceptionalism. The agencies, the police, the military, etc., they will exercise their powers then up to the point at which the legislation permits. And I think we see that in all sorts of contexts. And I would be interested in whether that is a presumption that should be made. In the context Amir seems to be working in, it seems absolutely that would be a presumption that the police will work right up to the, lawfully up to the limit they're allowed to. In the context Marion's looking at, it seems that perhaps there is a measure of saying, well, you might not work to the full scope of your powers, or you need to work in those in a particular way. I had a range of other observations, including around the question of fair trial rights, which I thought was a really interesting observation. And I work on the criminal law team at the Law Commission, so we are acutely aware of that as an issue. I think the learning from international experience across all those papers, I would also say, I think it seems to go without saying that international cross-border learning is absolutely important in this. So I will stop my comments there at 6 minutes. Thanks very much.
So I will take this moment to begin and say welcome back to everyone who's joined us from this morning, and then hello to everyone who may just be joining us. We return from two really excellent panels that have just taken place: Global Challenges in AI Regulation, and our panel just before the coffee break on public safety and AI. If you're just joining us, both of this morning panels will be made publicly available after the event. So please do watch them at a future date when you can. They're all really excellent papers and some great discussions. So now I am really delighted and thrilled to moderate and to introduce you to our distinguished keynote panel for our second day of the ILPC annual conference on AI and power. This panel focuses on international perspectives regulating AI. In terms of format for the plenary panel, much like earlier today, each speaker will present, and we'll follow this up with the time that we have remaining with a Q&A and some discussion. I have one amendment to announce regarding the lineup of the panel. Unfortunately, due to personal circumstances, Audrey Plonk from the OECD can no longer join us today, and she sends her apologies. So now it is my very great pleasure to introduce our first speaker, Professor Luca Belli. Dr. Luca Belli is Professor of Digital Governance and Regulation at the FGV Law School at Rio de Janeiro, where he directs the Center for Technology and Society and the CyberBRICS project. Luca is also an editor of the International Data Privacy Law Journal, published by Oxford University Press, and director of the Computers, Privacy and Data Protection Conference Latin America, CPDP LATAM. He is currently a member of the Brazilian Presidency's National Committee on Cybersecurity and also a board member of the Global Digital Inclusion Partnership. He has authored more than 80 publications on law and technology and policymaking, and his work to date, has been quoted by numerous media outlets, including the BBC, the Financial Times, La Stampa, and the New York Times. Luca, whenever you're ready, the floor is yours. Thank you.
Thank you very much, Nora, for the very kind introduction and kind invitation. It's really a great pleasure to be again with you at this excellent event, and also an even greater pleasure to share the floor with Martin and Franco, who are very professionals and good friends that I admire enormously. Now, as we have a couple of extra minutes to present our presentations, I have decided to include also a little bit of connections of our work on AI sovereignty, to contextualize it with our work on digital sovereignty and connect it a little bit with our work on data sovereignty and data governance in general. So let me share my screen so that I can also provide a little bit of references in case you are interested in further deepen the ideas and conversation with publications that we have recently released. I hope you can confirm that you can see the screen, right? My PowerPoint presentation. Okay, yes, right.
That looks great. Thank you.
All right. So first of all, let me also disclose that all the information I'm going to share, or the thoughts I'm going to elaborate on, they have originated primarily in this project that Nora already mentioned, this CyberBRICS project that is one of our flagship projects here at CTS, which is the only project in the world that analyzes and compares digital policies of the BRICS grouping, so Brazil, Russia, India, China, and South Africa. And now we are expanding to include also the new BRICS that have recently joined as of this year. Most of the projects, if not all, is conducted with a multidisciplinary approach. And we have a team that usually has a legal background, but we have a lot of data scientists, economists, sociologists. You see here part of the team of this project. They have very different backgrounds, and it is very important to stress that they come all from very different countries to enhance the coverage, and also have specialists on each of the BRICS grouping. Now, this is one of the first research outputs that we elaborated, that is also available in open access on cyberbricks.info. And it's important to mention this because to understand how we reached the discussion on digital sovereignty. So this project we have, CyberBRICS, was dedicated first to cyber security and data governance in the first phase, then to digital transformation strategy of the BRICS countries, and now to AI governance and AI industrial policies. And we ended up understanding when we were analyzing the first phase on cybersecurity that there was an enormous overlap between cybersecurity and digital sovereignty in what concerns the understanding the vulnerabilities of the technology that you are using, how the technology functions to reassert control and sovereignty, indeed, on the technology that we are using, both as an individual and as a state, right? So this is the conclusion of actually this book that was published 3 years ago. So it was the first part, an outcome of the first part. We elaborated more on this point in this other book that was published last year. If you read Portuguese, you can freely download it as well. And actually, it's very interesting that, so in this book, we highlighted that in both digital sovereignty and cybersecurity issues, it is needed to have an integrated approach and a multi-stakeholder approach, not to pay lip service to multi-stakeholder narratives, but because it is the only way to have a precise understanding of all the dimensions that digital transformation entail and that cybersecurity requires, and that are needed if you want to be digitally sovereign. So you cannot be cyber secure if you are not digitally sovereign, and you cannot be digitally sovereign if you are not cyber secure. That was the main goal of this publication, which actually has been very well received in Brazil. And this is the reason why I believe the primary reason why I was appointed as a member of this newly created multi-stakeholder body that advised the presidency of Brazil on cybersecurity, which is actually something that we proposed in the book, and it was created this year by the Brazilian presidency. Now, to have a better understanding of pretty much everything I'm going to mention today, in 10 days, you will be able to freely download this book. There is already an available webpage on the Cambridge University Press website. But the book is not available there yet, but you can already find the conclusion and the introduction on cyberbricks.info if you are interested. And in this book, so we have traced over the past 3 years, all the narrative, not all, but most of narratives and initiatives that emerged in the BRICS grouping as regard digital sovereignty. And it's important to stress that we adopted an agnostic approach because we know very well that digital sovereignty can be positive or negative. And can be something triggered by individuals, by local communities, by corporations, by states, even by supranational entities. And so we have really strived to analyze the entire spectrum of these dimensions to provide a good understanding to the reader of the complexity of the issues, and that beside digital sovereignty is a very nice label, but to understand really what we mean by it, and if it is something we want to promote or we want to avoid, one has to understand what is behind the label and what is concretely proposed, right? So what we have used as a working definition in all these publications I've mentioned, and even more, is of digital sovereignty as the capacity to understand, develop, and regulate digital technology, which is essential for the full enjoyment of self-determination, agency, and control over technology. And this is essential to achieve what our European friends would call strategic autonomy, what the Brazilian constitution called technological autonomy, which is really rooted into some of the BRICS countries' cultures at the constitutional level, like in Brazil, or for other political or particular sensitivities in other countries, like, for instance, Russia, India, or China, which have been traditionally skeptical about adopting foreign technology without understanding how this could be used potentially for manipulation, spying, surveillance, or meddling, and therefore have been more skeptical about it. Now, why this is interesting and why this connects with most of the issues that actually we already know when we speak about self-determination, one of the main tenets of data protection is informational self-determination. Now, in this paper that we've just released 2 months ago, we explore, looking at BRICS example, how data sovereignty is emerging. And we understand that actually it's very much connected to informational self-determination, not necessarily from an individual perspective. So the individual right to understand who is collecting data, how data are used, with whom they are transferred, and for what reasons they are processed, but also a collective dimension of it. So since at least 15 years, we know, thanks to World Economic Forum and others, that data is the new oil, is a new class of assets. But very few people understand that actually you should have also a collective vision on how to reap the benefit of data. If this is a new class of assets, you have to, and if this is really so valuable, you have to consider it strategically, right? And let the door open so that foreign tech giants can hoover it and reap all the benefits and advance in technological development, build intelligence, not only artificial intelligence, build new innovation out of it is not the smartest possible solution. And this is actually, if we look at the documents of the Chinese National Council of 2012, where they first started to understand, to design a strategy for data, they consider data as a strategic asset that should be used for the national advancement and national purposes. Now, of course, if you look at China from Western perspective, we always think that it's about being authoritarian and dictatorial. But there is a lot of interesting things that they have been looking at in China, in India, in other BRICS countries that we should consider more carefully. Actually, a lot of very renowned reports like the Draghi report or the Letta report that now are very famous in Europe, they very much consider what China, India have been considered over the past 20 years and reproduce this in different ways, without, of course, mentioning the inspiration. But actually, they have really looked at how China and India, or the US itself, they have developed over the past decades, and they reproduce this. They stress the importance of industrial policy. Now, another very important point that I want to stress here, before getting into the AI debate, is that there are very good examples of good digital sovereignty. And DPIs, digital public infrastructures used in India or Brazil, are a very good example. For instance, the Indian UPI, the Uniform Payment Infrastructure, or the Brazilian PIX, two digital public infrastructures for electronic payment. They are an excellent example of digital sovereignty. Before them, the only ways that India and Brazil had to process instantaneous payment was to use Visa and MasterCard. Two American corporations that have a duopoly, a global duopoly, but not anymore in India or Brazil, because India and Brazil, they have built their own digital public infrastructures. So they have not prohibited foreign corporations. They have created an alternative. So they have reduced enormously the cost of transactions, because even if the transactions are very cheap, Visa and MasterCard charge between 3% and 5% for every transaction. So that you revert immediately up to 5% of what you pay into people's pockets. And then they have broken the monopoly of data collection, because very few people realize in Visa and MasterCard that now they have become, over the past 10 years, big data corporations, not payment corporations. And so this has been broken so there is a very good impact on competition as well, not only on data protection. Now, another very good example that we analyze it and also in this other publication is community networks as crowdsourced, community-driven the example of digital sovereignty. So people that live in remote areas or in peripheral areas build their own connectivity infrastructure. And this is very common in Brazil, India, or South Africa. And so they understand the technology, they build the technology, and they regulate the technology. And these are a local community of slum dwellers. So we are not speaking about Silicon Valley tech guys. We are speaking about very common people that build their own digital infrastructures, understand it, and regulate them according to their needs, right? And so here we come to what is AI sovereignty, and I'm going to conclude with this. So I've defined this in a publication last year as the capacity of a given state, of a given country, to understand, develop, and regulate AI systems. thus retaining self-determination, agency, and control over such systems. This is something that I published last year in this paper. I presented it in May last year at this Carnegie conference and published there. And the basic tenet here is that risk-based AI regulation is necessary, but not sufficient to achieve AI sovereignty. It is necessary to regulate risks and to understand risks and to develop also technology that allows to cope with these risks. But that is only one of the, what I call key AI sovereignty enablers. It's something that I have also explored with a lot of other colleagues in this report that was released last year at the IGF, the Internet Governance Forum, and then became quite popular after that. Other think tanks started to speak about AI nationalism. Some big tech started to publish blogs about AI sovereignty, like for instance, NVIDIA or Oracle. Now they have blogs on their websites saying that basically if you purchase their equipment, you will be AI sovereign. That is a distortion, I would say, of what we call AI sovereignty. But this became a very popular concept last year. And so, what are the key AI sovereignty enablers that I have stressed in this publication that allow you to understand and be AI sovereign? So here is the full stack. So this AI sovereignty stack that I described in the publication, you will see that at the bottom there is a risk-based regulation, which means that you have to develop capacity to understand risk and regulate risk. But on each of these elements, you should have research, development, and regulation. Data, that is self-explanatory. I don't think that in this conference I have to explain why data are relevant for AI sovereignty and why it is relevant to develop and to understand data intense technologies, software algorithms, particularly LLMs and models. Again, if you don't develop them, it means that you will be a mere customer of them. And that is actually why Meta gives them for free, because they want to regulate AI development through software. Computational capacity. Very few people realize that actually we all depend on AWS, Google Cloud, and Microsoft for compute. So there is more than 70%, and I see that I'm almost out of time. More than 70% of the market is in their hands, except in China and in Russia, because they are not very welcome there. But the rest of the world depends on three corporations, and they all depend on NVIDIA, and NVIDIA depends on TSMC, so the Taiwan Semiconductor Corporation, which is, I believe, the main reason why the US are so interested in defending democracy in Taiwan, because everyone depends on Taiwan for top-notch semiconductors. The moment in which Taiwan will be integrated again in China, China will be the leading economy for semiconductors, not NVIDIA anymore. Electrical power, that is something that people are starting to realize how important this is for AI. And that is in the paper I had last year, an enormous competitive advantage for Brazil that already has 80% of his electrical power production is renewable, thanks to very abundant hydropower. So in Brazil, I believe Brazil has the potential to become a hub for computing power, due primarily to the very abundant renewable energy. Digital literacy, again, if you don't have digitally literate population, you are a consumer. You will never be a producer of AI. Cybersecurity, quite self-explanatory. If you build unsecure AI, you are building a time bomb rather than advancing. And of course, last but not least, risk-based regulation. It is last because I want to discuss the relevance of the others before arriving there, but it is extremely important. So this is not to say that risk-based regulation is not important. It is, but it's only one of the elements. Sorry, I forgot to mention meaningful connectivity, which is a very important one. I've just noticed now. Why this is really important? Because most of the global south is connected through, not to the internet, does not have meaningful connectivity, but most countries in the global south, they are connected only primarily to Meta's families of social media due to very skillful zero rating practice introduced by Meta over the past 9 years. So pretty much all the global south is not connected does not have meaningful connectivity. People are connected for free to Facebook, WhatsApp, and in some cases, Instagram. All the rest is paid. What does it mean? That even if you develop the best possible AI, people will not use it, will use meta AI because people don't have access to it unless you radically change meaningful connectivity policies, which is what India did in 2016. People hailed at India's prohibition of zero rating as if it was great freedom of expression implementation. It was digital sovereignty. It was a very good example of how you need to have meaningful connectivity as a basic infrastructural need to be AI sovereign. Now, to know more, these are the publications that are either upcoming or already published. And then I thank you for your attention. Thank you very much.
Thank you so much, Luca, for a really fascinating and comprehensive presentation, and for work that has been dealing with concepts and engaging with concepts, Luca, that we haven't dealt with, I think, in all that much depth so far in the conference proceedings. So thank you so much for that. I think your points regarding the significance of digital sovereignty and the importance of public digital infrastructure speaks so importantly to the theme of the conference and the use, deployment, access to these systems, and also not just the power asymmetries between the individual and the state and industry that many papers have focused on a lot during the conference, but also, as you rightly point out, the power asymmetries between communities and the state and communities and industry, and even the power asymmetries, tensions and dynamics between states and the industries within. So this is all, I think, a very important part of the conversation that needs to be explored more. And it was fantastic to hear all the work that you've done in this space to date. I'm a huge fan of the criteria you have regarding the concept of the AI sovereignty stack. And I mean, can I say things are hot off the press if a book is about to be publicly accessed by everybody? But I think it's very important to remind everyone about that the book on digital sovereignty in the BRICS countries that you co-edited to be published by Cambridge University Press is going to be open access very, very shortly. So Luca, thank you so much for that. Hope we can follow up more in the Q&A section. But now I am very delighted to introduce our second speaker. And before I do so, Franco, I just want to give you my advance apologies for any mispronunciations that are about to happen. So do forgive me in advance. So our second speaker, I'm delighted to say, is Franco Giordano-Gigani. Franco is a policy analyst for Access Now, a leading NGO that advocates and campaigns for the promotion and protection of digital rights internationally. Franco is a lawyer based in Argentina, and his areas of expertise and experience are in IT and intellectual property law. He has been an active member of the internet governance ecosystem for many years. At Access Now, he focuses on privacy, surveillance, data protection, and other related issues. And I understand that you, Franco, will be speaking on AI policy developments in Latin America. So, Franco, whenever you're ready, the floor is yours. Welcome.
Thank you, Nora. And I want to appreciate the invitation and having me here today. It is very humbling to go after Luca, who I think have explained marvelously the situation and landscape in Brazil. I will try to speak about Latin America, but leaving Brazil aside. So I will try to focus on the situation that other countries in the region are navigating actually at this very moment. But also, before I do so, I want to say that Brazil is definitely leading in terms of how to approach AI regulation and AI strategic development as a global South country in the region. So what I want to do now is kind of to have a step back in terms of analyze the situation in countries that haven't been able to explore their positioning and strategic as the way Brazil has done. So For this, I want to begin by saying that the regulatory race that we are actually witnessing in Latin America is both an opportunity and a challenge. In terms of opportunity, I want to echo a lot of things that Luca said about how the countries in my region sometimes seen more as a consuming countries rather than developing or producing countries, in terms of how we import technology, how we import AI at these very stages, and how that has become a situation that is really difficult to sort out, where we don't actually have the means to kick off a developing race that can put us into a challenging field with other powers such as the US, China, the EU, the UK, etc. And at the same time, we have to protect fundamental rights in Latin America. So the regulatory race seems to be, in that sense, very timely in the way that we have to move fast in order to make sure that fundamental rights are protected at all times in Latin America, while we explore the opportunities and that we have to play the AI developing challenge. And at the same time, I do think it is somehow problematic, because we as a region are very much short on things that are core elements to building digital sovereignty, as Luca was explaining. Some of them are, for example, high power computing, graphic processing units, data centers, cloud computing, etc., etc., etc. So we don't have really the infrastructure and the DPI to actually kind of back any strong developing strategy. So we have to do a lot of investment from the public sector. We have to do a lot of connections between the private and the public sector, and this will take time. This will demand a lot of resources. This will also demand a lot of collaboration from the academic sector, etc., etc., etc. So this is a lot of time that we in Latin America have to, we already have started exploring, but it's not going to happen as fast as it did in other regions. So this balance, or this imbalance, I want to say, between the opportunity and the challenge of regulating AI is creating a situation where the public sector sees AI as a tool to fix long-standing problems in the region, such as security. So what we have been seeing lately, I come from the civil society sector, is how surveillance tech have increased in the region, how militarization is being explored, how mass profiling, cyber patrol is being also enhanced in the context of, for example, migration policy. We have a huge challenge in this regard, with thousands of people making their way up to the southernmost border of the US, creating a situation where there's a potential humanitarian crisis, and I want to say that one of the main reasons for that is how the digital complex that was deployed by the US is actually infringing and causing harm to the migratory population. So with all of these factors, we do see we are very worried about how AI and technology and automatic decision is being used in the region. At the same time, when we explore the regulatory efforts in the region, we do see a clear influence of the EU AI Act. So we see how the Brussels effect is doing it's having its weight in the region, with more than 600 regulatory proposals in the region. Most of them are trying to follow the EU AI Act model in more or less. And this is something that we don't have a problem with. But we at the same time say that there has to be space for the necessary debates in the region, so that we debate, so that we arrive or we land to a regulatory design that is autonomous and is also working for us, because Latin America doesn't have the same situation, as I explained before, than the EU. So we do see how the influence of the EU AI Act is actually kind of circumventing all possibilities of having deep and profound debates around how to regulate AI in the region. At the same time, we do see that other regulatory efforts are trying to create new criminal offenses for the uses that generative AI allows. And this is a challenge for freedom of expression, of course, but at the same time, it's, as I understand personally, a misunderstanding of what AI technologies truly are all about. And I also want to share some publications that I think are very illustrative of the situation in Latin America. The first one is an index that was published earlier this year, which is called Índice Latinoamericano de Inteligencia Artificial, published by the Centro Nacional de Inteligencia Artificial. It's only in Spanish, I apologize, but I am sure that if you are interested, you can find the sections that you want to have a deeper look into and have them translated. I'm going to share that in the chat box so that you can have access. It's a PDF, so you can freely download it. And the second publication that I want to share is one that I authored, and it was published earlier this year, which basically covers the most important regulatory proposals that were presented in Latin America until December 1st, 2023. And also it covers many of the soft law tools that are being most influential in the region. This is analyzed from a very critical point of view, from a civil society point of view, of course, and it was translated into English, so you can actually find the information in the language that is best suited for you. And I want to finish my presentation reading or actually explaining a situation that happened in Costa Rica that I think is very exemplary of how the regulatory race sometimes is full of misinterpretations of what AI technology does and how to regulate it. First of all, I want to say that the Costa Rica parliamentary body presenting proposal that was kind of rapidly dismissed, but nevertheless, I think that the way they build the proposal is kind of exemplary, as I said before, because they use ChatGPT in order to create a bill to regulate AI. And I do want to read the prompt they introduced into ChatGPT, and I quote, think like a lawyer and legislative advisor, use technical vocabulary and generate a proposal for a law to regulate artificial intelligence, taking into account the 1949 Constitution of Costa Rica. Just ask whenever you have any question. And I think this last phrase, just ask whenever you have any question, is the one that I want to kind of reflect on for a few more seconds, because I do believe that this is where we have the best example or element to realize how much confidence we in Latin America are putting into the outcomes of AI and, for example, on LLMs. The fact that we believe that ChatGPT can actually give us feedback and ask when if the system encounters any sort of doubt when developing comprehensive bill to regulating AI, is actually giving ChatGPT or any LLM for that matter the autonomy, the sufficient autonomy to actually create a conversation or a thoughtful process to I want to say replace human capacity in a critical task such as regulating an emerging technology such as AI. So I do think this kind of give us this illustrates how Latin America is sometimes putting too much confidence in AI, is not understanding really the boundaries and the limits that AI technologies have. They are kind of creating a new, and this is also said with a twist of humor, kind of a new horizon for self-regulation, because we are asking AI to regulate AI, and this is something that I do believe needs more debate, more analysis, further collaboration from civil society and from academia. And so this, with everything I said before about the lack of the needed infrastructure to develop AI, is the situation where we are at the moment. Of course, as I said at the beginning of my presentation, Brazil is leading in this way. Other countries are following closer than others. For example, according to the index that I shared before, Chile is the one country and Mexico is the other that are following Brazil in all fronts. But there are other countries that have been historically very influential in the region that are not really coping up with this challenge, such as Argentina. And nowadays, with the rise of different governments in the region, such as Argentinians' current government, the regulation of AI have been totally abandoned in terms of there will not be any political momentum or support to regulate AI, and at least for the next couple of years, because Argentina believes that the lack of regulation can actually create or can actually contribute into creating a hub for AI development in the country. So I do see how many countries are trying to do the same. They have these national strategies that are coping with the context that they have. They're trying to understand the complexity of the task that they have in front, and they are trying to follow, as I said, these goals of having digital autonomy and so on. But there's also one element that I want to mention, that is the lack of collaboration between countries in Latin America in this regard, because even if we speak the same language, most of the countries in Latin America speak Spanish. The exception is Brazil. This is, being very general. And then even with that great condition of having the opportunity to understand each other very easily, we are not being able to collaborate at the moment. So we will see how it goes. This is where I will finish my presentation. I want to apologize in advance because I have to leave early. I have a personal situation to take care of, but I want to thank the invitation again, and I hope you have a great Q&A. Thank you.
And thank you so much, Franco. That was a really fantastic overview of AI regulatory and policy developments that are taking place across Latin America. There were some points that you raised, I thought, that were very interesting, and again, really warrant further explanation, but also exploration by researchers and policymakers in terms of points that relate back to some of Luca's arguments regarding the importance of advancements, yes, in public infrastructure, but also very interesting to see this distinct shift in other jurisdictions advancing AI policy development at regional levels for, say, LATAM and elsewhere. For instance, the policy initiatives by, say, the African Union on AI. It's very interesting to see that we have clear initiatives that are being put forward, I would say, beyond the traditional jurisdictions of, for instance, North America or Europe. And I think it's very important to see those other approaches taking place. I think it's very interesting that you mentioned the fact that there's also a focus now on mapping these developments. And thank you so much for sharing the index and the Access Now report that is providing an overview of how different developments are taking place. And I think the point you mentioned too about the divergence in AI policy priorities, but then the actual capacity on the ground to implement them, particularly within the public sector, is very important. And I think the case studies, specific examples you gave about the potential of misuse and abuse of a lot of AI-based systems for border management and public safety is very significant. And I would argue that that's not just a challenge that's relevant in Latin America and in the countries that you mentioned, but also it's a very pertinent and relevant issue that was debated earlier on today as well in Europe in terms of facial recognition technologies and predictive policing and drones and so on. And I also note as well the point you mentioned regarding the Brussels effect, as Anu Bradford's concept regarding the reach of EU legislation in this space. And I think another very significant point that you raise within the Latin America context is that there is no direct transplantation of these values and principles into legal systems that have very different constitutions in terms of particular safeguards, or have different conventions and rights that are strengthened or recognized either regarding the UN or other regulatory relationships. And that's just another element, as you mentioned, to be considered on top of the capacity of these countries to implement AI systems and then the additional safeguards. So Franco, thank you so much for all of those points. And it really does add, I think, a much richer and international discussion to all of the panels that we've had so far over the past 2 days. So thank you so much for that. That brings me to our final speaker of our panel, last but not at all least, who will be bringing us perspectives and insights from the EU, which we just mentioned with regards to the Brussels effect. And that is Dr. Martin Hussebeke. Dr. Hussebeke is Associate Professor of Law at the London School of Economics and Political Science, LSE. Martin's work investigates questions of innovation policy and digital liberties, in particular the regulation of online digital platforms, intellectual property, and freedom of expression. Martin is one of the leading experts on the EU Digital Services Act. He is the author of the monograph Principles of the Digital Services Act, recently published by Oxford University Press this year. He is one of the rapporteurs of the Council of Europe's Committee of Experts on Online Safety and Empowerment of Content Creators and Users. Martin has provided his legal expertise to numerous NGOs before the European Court of Human Rights in Strasbourg and the Court of Justice of the EU in Luxembourg in digital technology related cases. And in addition, Martin's work has also been cited on several occasions by the Advocate Generals of the Court of Justice in Luxembourg. Martin, thank you so much for joining us. The floor is yours.
Thank you so much, Nora. I hope you can hear me okay, because I had some problems getting into this. Thanks so much. This was really exciting to hear, especially the two previous talks that had this sort of a very high-level perspective on regulation of AI. And I guess I will again have a slightly different perspective on regulating AI, because instead of diving into the key act that is supposed to regulate AI in Europe, that is the AI Act, I will focus on what the DSA has to say about the AI. And I think one of the things I probably try to say is that it has actually a lot to say. And given that AI Act is still something that only has to kick in, it might be interesting to see to what extent we can already use DSA to regulate some aspects of AI. But I think another interesting story maybe underlying this is that we're getting into the regulation of AI, and many questions, and obviously when looking at regulation of AI, are somewhat related to the problems that we have with platforms, although they are not exactly the same. And I think it probably will be for a good reason that we will have a different regulatory regimes for platforms and for AI. I'll explain why. But I think inevitably there will be some of the problems and some challenges that will be very similar. Okay, so let me first start by saying what I think already is being regulated by the Digital Services Act when it comes to the different types of AI applications. So in the legislative process concerning the DSA, one of the big types of AI that obviously was already front and center in the debate were the recommender systems. So the recommender systems, particularly the news feeds on social media, were one of the things that legislature was quite concerned about. Another example would be the advertising recommender systems. So basically recommender systems that recommend us advertising and target our advertising. And the Digital Services Act, perhaps surprisingly, had a very little in terms of, it was little aspirational when it comes to regulation of these systems explicitly. So I think there is an interesting aspirational system that relates to risk management, but when it comes to explicit rules, if you think about it, we don't have a really far-reaching explicit rules. So basically, all the explicit rules related to recommender systems or advertising recommender systems are mostly about transparency, to some extent about choice, but even that choice is not about the defaults, but it's mostly about building in some opt-outs. So a DSA requires, for instance, that very large online platforms build into their systems a possibility for the users to opt out of the recommender systems that are based on profiling. So this kind of non-profiling based opt-out applies to all recommender systems on all the platforms, and all the AI systems that do any recommendation on the platform will be falling into the recommender systems definition because it's incredibly broad. And this is not only about recommendation of non-editorial user-generated content, but also editorial content. So essentially, any recommendation generated to user on an online platform is something that is subject to this regulation, and only if the provider is a very large online platform, this obligation to offer an opt-out will exist. Now, what companies have done with this, they try to implement, particularly for the recommender systems that everyone is familiar with, such as the newsfeed. They try to implement sort of opt-out options that are based on, geography. So you get a localized feed based on where you are, or you get reverse chronological newsfeed and things like that. I think it gets more challenging if you try to think about all the recommender systems, because recommender systems are all over the place when it comes to digital services, because you always have to prioritize information. And I think we have a long way before we get opt-out options on all of these services, even on the very large online platforms, including when it comes to advertising, because advertising is also a type of recommender system. But that is one of the ways. So transparency, explaining the criteria, explaining a little bit more who is advertising and how certain recommendations are made. This has been sort of the main approach in the DSA when it comes to explicit rules about recommender systems, and the opt-out then as one of the possibilities for the choice. So another bucket of rules that relates to some AI systems in the DSA concerns the content moderation tools, obviously. So content moderation obviously is to a large extent powered these days by AI systems, particularly LLMs that are trying to learn about what potentially hate speech is or other types of unlawful or otherwise content that is prohibited by terms and conditions. And here, I think the main contribution of the DSA is twofold. One is the fact that it again increases transparency by requiring companies not only to include certain reporting on biannual basis of what type of tools they are actually employing, but also interestingly, and I think this is again a work in progress for many years to come, to report on the accuracy and weaknesses and safeguards built into these tools. So in other words, if you're using a hate speech detection system going forward, you should be reporting the accuracy rates for these systems. You should be reporting on the weaknesses of these systems and the safeguards that you're trying to implement on top to prevent that you're removing innocent content. And I think that's quite interesting. I think I wouldn't necessarily say that that so far we're seeing over implementation of this, but I think potentially going forward, this is a very interesting tool that can be very interesting because it can force the entire supply chain of the tool makers to basically do a better testing of their tools, because they will need to report those numbers to those who want, to their clients who want to use it in the content moderation. Because one of the things that we're seeing is that all the content moderation on the services is essentially being fragmented into components where different vendors are coming in and supplying tools that are then sort of brought together by the providers. So providers are increasingly relying on external tools, even if they're big ones. Essentially, no one is anymore relying only on internal tools, but there's more and more market for the tools. And if we add on top transparency for these tools, this is a very interesting development. So the other obvious change that the DSA brings is in the area of procedural rights, because by creating these procedural rights, allowing us to contest the decision-making of the providers, we're also potentially improving precision of these tools. And this is kind of another way how DSA is trying to push at some of the problems related to AI systems, particularly the problems related to the accuracy of the decision-making. I think it's quite telling already that if you look at both recommender systems as well as the content moderation tools, there's a lot of sort of a cross-pollination, or at least sort of a related problems that we see both in the area of GDPR data protection and DSA. Because some cases that have come up, for instance, on the enforcement of the DSA related to content moderation, were in parallel run also as the GDPR cases. Why? Because the plaintiffs would try to frame a content moderation decision by an AI system as a type of automated decision making, which triggers certain safeguards under the GDPR, and at the same time, they would also frame it as a content moderation decision under the DSA. So it's quite interesting how the two are running in parallel, potentially reinforcing themselves. The same thing about the recommender systems, where I think there's a lot of push from the DPAs trying to look closer at the recommender systems and go beyond the transparency. So those are kind of two basic ones that we can say are explicitly in the DSA. Now, the more interesting is the one that is much more principle-based co-regulation, and that is the regulation on the very large online platforms of any AI components used by online platforms through the general system of risk management. And this system basically works through the annual cycle of risk assessment, which is then followed by certain audits, and then followed by certain follow-up by the platforms, and then by the review of the regulator, who looks at all the risk assessments and audits from all the companies at once, and looks at whether it is satisfied in terms of how companies are mitigating risks. Now, the scope of the risk is incredibly broad. Everything that you wished for to be regulated in the AI Act is clearly under the radar of the DSA risk management system. So the scope problem is really not there. Everything that is potentially relevant and potentially discussed in the AI safety debates is definitely present there. Now, one of the interesting things, which basically means that companies are forced to think about the AI components related risks as a part of the DSA risk mitigation strategies, because they implement the AI systems into a regulated product, which is the product that builds upon the user-generated content. Okay, so essentially offering a VLOP service, so very large online platform service, becomes a regulatory layer that forces you to conform with a certain risk management of different types of risks, sometimes potentially even going beyond what AI Act requires, because of the product into which you're incorporating those AI systems. So I think that's the first interesting thing. So essentially, in other words, anything that companies that end up being VLOPs throw into their systems ends up being subject to this additional layer of scrutiny, in addition to any sort of product regulation of the AI systems. Another interesting thing that related to this is the question of, okay, so we have the VLOPs as the category of services that are regulated. Now, what exact components are regulated? What exact services are regulated? And this is quite interesting, particularly from the perspective of which services aren't regulated by the DSA. So very large online platforms are basically defined as, the services that would store other people's information, distribute that information to the public, and have in the EU more than 45 million monthly active users. So at the moment we have 20 plus very large online platforms in the EU. Essentially, most of the social media, sort of well-known social media services, but also marketplaces, several adult sites, Wikipedia, Google Maps, and etc. And these services, to the extent that they incorporate an AI feature, will be regulated also for the safety of that AI feature. However, there are services which might be big enough from the European perspective, meaning they have enough users, but they might not necessarily qualify for this definition of storing someone else's information at their request and distributing it to the public. And the example here would be the typical standalone LLM models like OpenAI, because OpenAI, while it might be learning from user-generated content, they do obviously scrape a lot of user-generated content from the internet. The key problem is that they do not receive this information from those who from whom the information originates, meaning it's not Reddit necessarily that is submitting this information to OpenAI, but it's OpenAI coming and scraping this information, essentially the same way as the search engines have been operating for years and years. So, and because of that tiny difference, it's already very difficult to say that it would be regulated by the DSA, because the information is not submitted to the providers, and hence it's not really in the remit. The second problem is obviously, and that relates to perhaps why it's a good idea to have DSA regulate platforms that are about user-generated expressions and online safety related to AI, regulating AI systems as two separate categories, is the fact that what the self-standing LLMs like the, say, OpenAI produce is not necessarily a reflection of user-generated content. So it's not a reflection of what people say. It's something that is composed on top from the corpus that the system learns from, but it's a unique, separate, new expression that doesn't simply regurgitate what people have said and attributes it back to the users, which even a search engine, you could say, is, but the kind of OpenAI type LLM certainly isn't. In other words, the big difference, and I think this is also quite important from civil liberties perspective, between regulating, say, OpenAI LLM and the say AI system that just organizes user-generated content, is that the latter organizes human expressions, well, to the extent that it's still humans speaking out there online, organizes human expressions, and it's basically reflecting human expressions and distributing human expressions to others, while in the first case is essentially just some sort of content that is created on top, some synthetic content that is created based on learning from human expression. So you can probably imagine how the the civil liberty boundaries for the latter, where humans are involved, are much stricter than the boundaries that relate to a product that produces something that is synthetic. So, and I think for this reason, it probably makes a lot of sense that we keep services like OpenAI's different LLMs out of the DSA, unless they are used as features to organize user-generated content within online platforms. And by extension, I would say it also makes probably a lot of sense that we regulate them differently, meaning perhaps more strictly than the ways that we regulate by default some LLM systems that are implemented in services that relate to user-generated content. So I think that's quite interesting. Sort of what it basically means, if I summarize all of this, it means that DSA is capable quite substantially to regulate on the product level the different types of AI systems that are used in online platform services, particularly if they're implemented by the very big players. And the obligations often trickle down to the ecosystem, because if you have vendor who has to supply some tool to a big provider, obviously the big provider won't do all the testing on its own, but will ask its vendor to do the testing. And that means that basically the obligation trickles down through the supply chain. Where the DSA has nothing to offer really is the area where you have a self-standing tools that are sort of based on scraping, which is how many of these LLMs are built. But perhaps that's for a good reason, because the DSA type of regulation is too weak, and maybe we need to go further than that. Now, whether the AI Act is the best response, I'm not going to comment on. I leave that for experts on that specific act. I have my doubts, but I think I just want to make the case that I think it makes sense that we actually separate use of AI as a feature within products that are really organized around humans and the interactions, and the systems that are used for completely different use, where they look much more like products to me, meaning regular products. And this is obviously where the ideological basis of the AI Act is, right? The product regulation. So I think that's what I would sort of say broadly. I think one last thing I would say, I think the big question about the efficacy and usefulness of the European sort of risk management system in a DSA depends on how well this risk management cycle will work. And that obviously depends on how well the companies will do in the risk assessments, how well the auditors will do, how well the commission will do. But one interesting feature that I think none of us really thought of back in the day is that the risk management cycle in the DSA actually isn't annual, as it would seem in the law itself. Because what the law says is that you do an annual risk assessment that goes to the auditors and everything. But the law also forces companies to do ad hoc separate risk assessments of any new features that might have a critical impact on the risk profile of a company. Which means that if you're integrating, say, a chatbot into your social media site that will chat with the minors, that could quite easily be a feature that has a critical impact on your risk profile. And that means you need to do separate risk assessment before launching that specific tool. Because if you don't do it, you end up as TikTok did, because TikTok wanted to launch a TikTok Lite service in Europe, in Spain, and France. They either didn't do the sufficient risk assessment, or the extent of risk assessment wasn't sufficient from the view of the commission, whichever of the two it is. The point is, the commission was of the view that there wasn't sufficient risk assessment done before the launch of this specific product, and was ready to move to get interim injunctions against launch of this specific product. Would you let then TikTok to withdraw this specific product in Europe and then enter commitments to say we will not launch this without having a proper risk assessment, which basically tells you that a commission is in a situation where even at critical features and many LLM models implemented into these services often can, I think, impact the critically the risk profile of companies, will basically mean that this will be subject to separate risk assessment that has to be done outside of the cycle. And I think that basically just strengthens the obligation of the ESA that you're moving from sort of a move fast and break things into sort of a innovate but validate approach, as I called it in the book. Now, there's a risk that we overdo it, and the companies will have to do separate risk assessments for every single feature, and I don't think that would be good either. So we need to be careful there as well. But I think that's just one of the interesting things that people might not realize about the ESA and its impact on these features. Okay, I think I stopped there. I don't know how much time I took. Hopefully I was within the time.
Just very quickly sum up here that this has been a really fantastic 2 days over the proceedings of the entire conference. We've dealt with so many issues that clearly still need to be grappled with by academics, researchers, policymakers in regulation and governance of AI, particularly from the perspectives of the intersections and dynamics of AI and power and the power symmetries that we mentioned in the panel today, but also that speakers examined in so much thoughtful and insightful detail over the past 2 days. A very special thank you again to Dana Boyd for her excellent and truly inspirational keynote yesterday, which I hope you can check out at a later date on recording, on interventions, not solutions in the era of AI policymaking. And many, many thanks again to our speakers on this keynote panel, all of our speakers over the past 2 days, our wonderful chairs and discussants, for everyone's fantastic contributions, including to our audience members for some really insightful questions and comments over the past 2 days. I hope this is just the beginning of a lot of these conversations. I hope we will all be back again next year to follow up on a lot of our predictions and thoughts that we shared this year. So wherever this finds you in the world, I hope you have a very good rest of day, a good evening, and I hope you will join us soon again for another event at the Centre. Thank you and goodbye.